In this episode, I would like to discuss about one important section of the Indian Contract Act, that is section 17, which defines the term fraud. What is the meaning of the fraud? What are the ingredients of fraud? And what are the consequences if the fraud is exercised by someone else in order to induce any person to enter into the contract? That means if any person induce the other to enter into the contract, then what will be the consequence? Whether the contract will be considered as valid or void or voidable. This is the topic of discussion today. Section 17 of the Indian Contract Act defines the term fraud. So, the section 17 says that fraud means and includes any of the acts committed by the person or by his agent or with his connivance with intent to deceive someone or his agent or to induce any person to enter into the contract. So, the following acts means that suggestio falsi. Suggestio falsi means the false suggestion. The person is giving some false suggestion to a person to induce to enter into the contract, or suppressio veri, that means suppression of the material facts, that active concealment, the contracting party actively conceals something from the other contracting party and thereby influencing that person to enter into the contract, or it is exercising upon either him or upon his agent. Or it may be that a false promise, that means a promise made without any intention to performing it, or any act which is fraudulent. So, any fraudulent act or omission may be like this, and ultimately it is made for the other party inducement so that the other party can enter into the contract. So, ingredients of fraud are like this, that it is actually an act or omission done by a contracting party or by his connivance or by his agent with intent to induce the other person to enter into the contract, and it is a kind of suggestio falsi or false suggestion, or suppressio veri or suppression of the material fact, or it is made some promise made without any intention to performing it, or any active concealment of any fact, or any fraudulent act done, and ultimately the other person, means other contracting party, has entered into the contract. So, let us have a look that section 17 defines the fraud. Following acts committed by either the contracting party or with his connivance or by his agent with intent to deceive the contracting party or his agent or to induce him to enter into the contract. So, ingredients of fraud are act done by either contracting party or with his connivance by someone or by his agent, a suggestio falsi or false suggestion, suppressio veri or active concealment, active act with intent to deceive, a false promise. So, act is made with intent to deceive, practice deception upon other, and a false promise, and fraudulent act or omission, and being defrauded the other person has entered into the agreement. So, I will discuss the each ingredients later on. Now, I would like to discuss about the first element of fraud, that is suggestio falsi or false statement of the fact. That means if any person knowingly makes any false statement or which he does not believe it to be true and made in a reckless manner or careless manner, and actually it was decided, these ingredients were decided by a landmark judgment of House of Lords, that is Derry versus Pick. What happened in this case, that the plaintiff filed the suit against the company because plaintiff purchased various shares of that company. Actually, company issued one prospectus, and the prospectus made one representation, and which shows that the company, by virtue of a special act passed by the parliament, was empowered to run the trams by steam or mechanical power. but there was requirement of prior approval by the Board of Trade. That was not mentioned in the representation, and the plaintiff purchased the shares, but ultimately later on the Board of Trade refused the permission and the company was wound up. Now the plaintiff filed the suit against the company because of such false statement, but House of Lords decided that this is not the fraud on the part of the defendant company, because in order to constitute the fraud, what is the most sine qua non or indispensable thing, that is most essential, that is the false statement must be made knowingly. But here the Board of Directors actually believed, having their good faith, that the company is empowered to run the trams by the use of steam or mechanical power, since it is authorized by the Act, but there was subject to approval of the Board of Trade. But Board of Directors thought that since the Parliament has authorized it, so it will be granted by the, positively the consent will be given by the Board of Trade, which was ultimately refused. So that's why court said here that in order to constitute the suggestio falsi, the ingredients are that the false promise is to be made intentionally, and having belief that it is false, but he makes the statement as if that it is true, and it must be made in a reckless or careless manner. But in the instant problem, court decided that it is not fraud on the part of the defendant company. So here the first element is suggestio falsi, or false suggestion or false statement of the fact, as I have said, and the case is, as I have discussed, that Derry versus Pick 1889, and false representation in case of made knowingly, without belief of truth, and recklessly, carelessly about true or false. And special act of parliament, that is the gist of the case, that special act of parliament, as I have stated, authorized the company to run the trams by steam or mechanical power, but subject to approval by the Board of Trade. So if the representation, false representation is made knowingly, then only it will constitute the fraud, otherwise not. There is one difference which is required to be mentioned while discussing the point of fraud, that is, what is the difference between mere expression of opinion and false representation. Expression of opinion will not constitute the suggestio falsi, but false representation actively, that means having belief it is to be false, it will constitute the suggestio falsi, that means fraud. So one example can be cited, that what is the expression of opinion, that is, a person, Mr. A, is seeking the job. Before the employer, he represents that though he is aged about 40 years, but he represents that he can act, he has the ability to act like a person of 20 years. So that is a mere expression of opinion, that will not constitute the suggestio falsi, and thereby it will become the fraud. But fraud or suggestio falsi means active false statement, that is, if any person at the time of making the insurance agreement, Mr. A is insured and he is making a false statement before the insuring company that he is the aged of 40 years, but actually his age is 50 years. So he is stating the false statement before the insuring company that he is the aged of 40 years, but though in fact he is aged about 50 years. That is the false representation. So here expression of opinion and false representation, there is the difference, that is, Mr. A expresses before employer that he can act like a person of 20 years of age, though he himself is of 40 years. This is the mere expression of opinion, that is not fraud. But false representation is Mr. A is insured showing his age about 40 years, though he was of 50 years. So here he intentionally make any person believe that he is aged about 40 years, though he is aware he is aged about 50 years. That is the active false representation. Now I am coming to the next ingredient of fraud, that is suppressio veri or active concealment of the fact. So, if any person suppresses one thing or suppressing a fact and thereby induces any person to enter into the contract, that is also amounting to fraud. One example can be cited that Mr. A is selling out a plot of land to B, then again he is selling out the said plot of land to C, suppressing the earlier sale. That means he has already sold out the property in favor of B and he suppressed it, and again he is selling out the same property in favor of C. So, this is the clear suppression of the material fact, that means suppressio veri. So, let us have a look that suppressio veri or active concealment of fact is this: A has sold out a plot of land to B and then again sold it to C, suppressing the earlier sale. So, it is a suppressio veri or suppression of the material fact. Now, I would like to discuss about what is active concealment. What is the meaning of active concealment? It was decided by one landmark judgment of Supreme Court in AIR 1968, that is Ningawa versus Bairappa Siddappa Hirekurabar. So, in this case what happened, that husband persuaded his wife to sign in a document and he disclosed before the wife that he is going to mortgage two property belong to her wife and thereby to secure the loan. So, husband is persuading the wife to enter into an agreement to sign the paper and disclosing her that he is going to mortgage two property belong to his wife in order to secure the money by way of loan. But ultimately in fact he mortgaged four properties belong to the wife. So, that means husband persuaded the wife to sign the paper disclosing that he is mortgaging two property belong to the wife, but in fact he mortgaged four properties. So, that means this is the suppression of the material fact, that is the active concealment on the part of the husband. So, court decided that it is the fraud on the part of the husband. So, that means what is active concealment? That means in this judgment, that is Ningawa versus Bairappa Siddappa Hirekurabar AIR 1968 Supreme Court, it was decided by our apex court that since the husband persuaded the wife falsely representing that he is going to mortgage two property belong to the wife, but in fact he mortgaged four property. So, that means it is the clear suppression of the material fact, that is the active concealment. So, it is the fraud on the part of the husband. Now, I would like to discuss about when there is duty to disclose about the changed circumstances by one party of a contract to the other. That means if there is any change of the circumstances, then the party who is aware of such change is bound to disclose it before the other side. If he doesn't, then it will be considered as active concealment and the contract can be rescinded on the ground that it is the fraud. So, a case can be cited in this regard, that is With versus O'Flanagan. The case was reported in All England Reporter in the year 1936. What happened in this case, that one medical practitioner, means doctor, that is O'Flanagan, entered into a contract to sell out his practice. Now, he started the negotiation in the month of January 1934, but ultimately he executed it, signed the agreement 1st May 1934. But by this time there was change of circumstances because of his acute illness and continuous absence from the practice. There was considerable degradation of his practice, means it actually came to an end, it considerably fallen. So ultimately when the other side purchased that practice, then they found that there was not actually existence of any practice because of these circumstances. But these circumstances was not disclosed by doctor to the purchaser. So that means he was aware of the circumstances that there is considerably fallen state of the practice, but being aware, he did not disclose this to the purchaser. So court decided that in these circumstances the purchaser has full right to rescind the contract. So the purchaser filed the suit for rescission of the contract, and the court gave the verdict that yes, it is subject to rescission because it was non-disclosure of the fact. So duty to disclose the changes. So the landmark judgment is With versus O. Flanagan, 1936, All England Reporter. It was decided that since the doctor has not disclosed about the change circumstances to the purchaser, so that means the purchaser is entitled to get the degree of rescission of the agreement. Now I would like to discuss about the explanation attached with section 17, which says that mere silence as to the fact that may likely to affect the willingness of a person to enter into the contract is not fraud unless it is the duty on the part of the person keeping silent to speak, or unless his silence is equivalent to speech. Now, 4 illustrations are stated in section 17 itself. Now, first says that Mr. A is selling out a horse by way of auction to B, which is unsound, and A is aware of it that it is unsound, but he does not disclose about the unsoundness of mind of the horse before B. But this is not fraud on the part of A, because here A is not duty bound to disclose everything before B. Second illustration stated that Mr. A is selling out a horse which is vicious or unsound mind to B, that is his minor daughter just come of the age. Now, as a father, it is his duty to disclose about the defect of the horse before the daughter. So, in this case, if he does not disclose, it is fraud on his part. Third illustration stated that when the auction takes place, if B is asking A that whether if you do not deny, I will consider that the horse is sound, but he keeps silent. In these circumstances, being asked by B if he keeps silence, that means it is equivalent to speech. So, if he does not say anything, or if he keeps silent, that means it is fraud on his part. And the last illustration stated that there is a contract entered between A and B about the sale of any commodity, the price of which is change, and about the change of price, the information come before A, not before B. So, it is the duty on the part of, not duty on the part of A to disclose it before the B, because A is not duty bound to disclose such change of the price before B. So, if he does not say to B about the change of the price, it is not fraud on the part of A, because here it is not duty on the part of A to disclose about the change of price to B. So, I have written here very brief manner about the explanation that mere silence is not fraud, that may affect the willingness of the persons, as I have discussed. So, unless it is duty on the part to speak, or unless silence is equivalent to speech. And the illustrations as mentioned in the section 17 itself, that A sells by auction unsound horse to B, and if B is A's daughter just come of the age, as I have discussed, and if B says that if you do not deny, then I will consider to be a sound minded horse, and A and B being the traders. The illustrations just now I have discussed. So, these are the examples and attached with the explanation along with section 17 itself. If there is means of discovering the truth, then keeping silence will not tantamount to fraud. That means, if there is any way to discover the truth, then the mere keeping silence will not tantamount to fraudulent conduct. So, in this case, 2 judgment can be cited. First is Keats versus Earl of Cadogan. What happened in this case? The case dates back to 1851. The landlord let out the property to the tenant, but the house was in dilapidated condition or ruinous condition. But tenant later on, when he discovered about the ruinous state of the house that was let out to him, he filed the suit for rescission of the contract on the ground of fraud on the part of the landlord. But court decided that there was ample opportunity on the part of the tenant to discover the truth, that means to ascertain about the conditions of the house. but he did not apply it. So, that means it is not fraud on the part of the landlord. Landlord merely kept silent about the condition of the house where there is the ample scope of the tenant to ascertain the conditions of the house, it will not tantamount to fraud. And in another case, it is decided by our apex court, Supreme Court of India in the year 1976, that is Sri Krishna versus Kurukshetra University. What happened in this case in a brief manner, that one LLB student, one student of law, he has the shortfall of the attendance, and that was the minimum percentage was required for appearing the exam, but still he filled up the exam though there was the shortfall of the attendance. Now, as a result, when university discovered that there is the shortfall of the attendance, they decided to cancel the candidature of the student, but because on the ground of fraud, since he has not mentioned that shortfall of the attendance during filling up the application form. But court decided that university should have got the opportunity to verify whether there is shortfall of attendance or there is the minimum attendance required is satisfied, because there was the chance on the part of the university to discover the truth, but university, there is the latches on the part of the university. So, that is not fraud on the part of the student. So, here I have written this very brief manner, that first was the meaning of discovering the truth, that is Keats versus Earl of Cadogan 1851, that landlord let out the house to the tenant in ruinous and dangerous condition, but court did not allow the relief to the tenant since he had the means of discovering that condition. And similarly, Sri Krishna versus Kurukshetra University IR 1976 Supreme Court, that one LLB student was short of attendance but still filled up the exam form without mentioning that, and university wanted to cancel his candidature on the ground of fraud, but court held it is not fraud since university had the means to discover the same. So, it transfers from the here that mere keeping silence will not tantamount to fraud if there is the means of discovering the truth, that means ascertaining the truth. Now, I would like to discuss about the one Latin maxim, that is contracts uberrima fiat, that is connected means with the concept that when there is the duty to speak the truth. So, contracts uberrima fiat means that contract based on the good faith, extreme or utmost good faith. So, if by nature the contract is such that there is the existence of utmost good faith, then the contracting party must disclose the true information to the other side. An example can be given, the means LIC agreement. So, in LIC agreement, it is the agreement based on the contract uberrima fiat, that means the assured person is bound to disclose all the relevant informations about his age or illness to the insurer company. So, one landmark judgment of Kerala High Court decided in the AIR 1986, that is P. Sarojan versus LIC. So, in this case, the assured person did not disclose the true information relating to his age and illness before the insurer company, and ultimately court decided that it is fraud on the part of the assured person, because LIC agreements are based on the contracts uberrima fiat, that means the assured person is bound to disclose all the relevant information relating to the age and illness to the insurer company. So, in this case, that is P. Sarojan versus LIC, it was decided that since there is the non-disclosure of the material fact or there was some false representation, then it is the fraud. So, I have written there the duty to speak, that is contracts uberrima fiat, that is contracts based on the utmost good faith, as I have said, and the case is P. Sarojan versus LIC AIR 1986 Kerala, and assured person here gave the false information to the insurer and court held that it was fraud. So, here it was fraud on the part of the assured person since he did not disclose the true information before the insuring company. Now, I would like to discuss about the circumstances when the non-disclosure of the marital status may tantamount to fraud. So that means according to section 12 subsection 1 clause C of the Hindu Marriage Act 1955, if the consent of the spouse is obtained by exercise of force or fraud, then it is subject to annulity, means the marriage will be considered as a voidable marriage. That means in case of marriage, the consent of the spouses must be obtained freely. So if there is the lack of free consent, that means consent obtained by exercise of fraud or fear, etc., or force, then the agreement of marriage becomes voidable. So one judgment is there, that is Rajinder Singh versus Promilla, AIR 1987, Delhi High Court judgment. So what happened here, that the husband was the divorcee and he did not disclose the same before the wife and obtained the consent of the wife without disclosing the fact that he was divorcee, means he earlier married and then there was the divorce. So this non-disclosure of the material fact considered by the court of law, it is the ground of nullity of the marriage. So the marriage was declared as null and void because it is hid by section 12 subsection 1 and clause C, that if the consent of the spouse is obtained by fraud, then it is voidable. So here in the instant case, the husband did not disclose his earlier marital status before the wife, and the wife consented to such marriage without this knowledge. So when it was disclosed, then the court said that this is the kind of voidable marriage and it is subject to be annulled. So when non-disclosure of marital status is fraud, that is related with section 12, as I have said, subsection 1 plus C of the Hindu Marriage Act 1955. So the relevant case is Rajinder Singh versus Promilla, AIR 1987, Delhi. So husband was a divorcee and did not disclose about previous marriage to the wife. So wife's consent was obtained by fraud as per section 12 subsection 1 and C of the Hindu Marriage Act 1955, as I have disclosed, and was liable to be annulled by the order of the court. Subsection 3 of section 17 says that if any promise is made without any intention of performing the same, it is also fraud. So if any person makes any promise having intention of not performing the same, it is fraud on his part. Example can be given that if any person has borrowed some money but with intention that he will not make the repayment of such money, that means he will not return such loan amount along with the interest, that is the fraud on his part. And similarly, if any person purchased some commodity but with intention of not making any payment against such commodity, that is also fraud on his part by virtue of subsection 3 of section 17 of the Contract Act. So here section 17 subsection 3 means a promise made without any intention of performing it, and examples like loan taken with intention of not repaying the same, and also purchase of a commodity with the intention of not paying the same. So these are also coming within the purview of the definition of fraud. Now I would like to discuss about subsection 4 of section 17, that is any other act fitted to deceive. So what does it mean by the term that any other act fitted to deceive? As mentioned in subsection 4, it means the fraudulent act or deception which is not covered by earlier subsection 1, 2 or 3 of section 17. So one case can be cited, that is Edgington versus Fitzmaurice, decided in the year 1885. In this case, now one person borrowed the money for a particular purpose, but he misrepresented the creditor the different purpose. That means he did not disclose for what purpose he obtained the loan. For one purpose he obtained the loan, but misrepresented to the creditor some different purpose which was not real. Though the object of the obtaining the loan was not unlawful, but the misrepresentation, this type of amounting to fraud as decided by the court. So what happened, that subsection 4, that any other act fitted to deceive, means Edgington versus Fitzmaurice 1885, as I have stated, that it is a fraud to obtain the loan by misrepresenting the purpose, though object is not unlawful. The object of obtaining the loan was not unlawful, but still he misrepresented to the creditor. So, that tantamounts to fraud, because it is coming under this subsection 4, that is any other act which is fitted to deceive. Now, I would like to discuss subsection 5 of section 17, which says that any other act or omission as the law specifically declares to be fraudulent. So, it means that if by any other special act, any act or omission is declared to be fraudulent, and an example can be cited that like section 55 of the Transfer of Property Act 1882. Section 55 subsection 1 clause A says that every seller is bound to disclose before the buyer if there is any material defect of the property to be sold, or if there is any defect in the title of which the seller is aware but buyer is not aware. And similarly, according to section 55 subsection 5 clause A, the buyer is bound to disclose to the seller if there is any some circumstances which may increase the interest of the seller over the property of which the buyer is aware, but he has the reason to believe that the seller is not aware, then he is also bound to disclose it. So, subsection 5 says that any such act or omission as the law specially declares to be fraudulent, and section 55, as I have cited as an example that of the Transfer of Property Act 1882, subsection 1 clause A deals with when the seller is bound to disclose, and subsection 5 clause A says that when buyer is bound to disclose, as I have discussed right now. Section 19 of the Indian Contract Act deals with the consequence of exercise of fraud, coercion or misrepresentation upon the contract. So, according to section 19 of the Indian Contract Act, if the contract is induced by either exercise of coercion or fraud or misrepresentation, the contract is voidable at the option of the party whose consent was so thereby caused. So, that means if anybody's consent was caused by exercise of coercion, fraud or misrepresentation, as the case may be, the contract is voidable at the option of the person. And in this aspect, one case can be cited, that is Akhtar Jahan Begum versus Hazari Lal. In this case, it was decided by Allahabad High Court. What happened in this case, that the seller sold out a property to the purchaser and disclosed him that if there is any defect of title on his part, then he will not be responsible to the purchaser. And actually he has earlier occasion sold the same property to some other person. Subsequently, he sold that property to the new purchaser. That means he has sold out one property to the purchaser, and that property already been sold out to some other person. So, that means court decided that this is a clear fraud on the part of the seller. And section 19 says that though there is exercise of fraud, but the person whose consent was so thereby caused can insist the performance of the contract. That means though there is exercise of the fraud, but it may not be voidable if the person whose consent was so thereby caused insist upon the performance of it. And moreover, it is stated that there is one exception, that if there is any way of discovering the truth about the fraud, then also the contract is not voidable. So, if there is any way out or means to discover that about the fraud, then the contract is also not voidable. And moreover, if the fraud did not cause the consent of the person, then also the contract is not voidable. So, it means that if the fraud has no leading role to play, so that it can cause the consent of the person, that means the person, though there is exercise of the fraud, but the consent of the person was not induced by the fraud itself, then it is also not voidable. So, let us have a look that section 19 says voidability of the agreements without free consent and voidable at the option of the party whose consent was so caused. Akhtar Jahan Begum versus Hajarilal, the case already I have cited, and whose consent was caused by fraud etc. may insist the performance. He can insist. An exception is it is not voidable if there is a means of discovering the truth. So, if there is any chance of discovering the truth, then it is also not voidable. An explanation say if the fraud did not cause the consent, then the contract is not voidable. So, if the consent has not come out by exercise of the fraud, then it is also not voidable. So, section 19 discusses about the consequences of the fraud.